Good morning, everyone.
Good morning.
Good. It is now 10 a.m., and I will call the meeting of the District of Columbia Board of Ethics and Government Accountability to order. I'm Bega Chairperson Norma Hutcheson, and this meeting is being held at the Board of Ethics and Government Accountability at 1030 15th Street Northwest, Suite 700 West, and virtually. Joining me today for this meeting are board members Charles Nottingham, Felice Smith, who is joining virtually, Darrin Sobin, and Melissa Tucker. Together, the five of us constitute a quorum for this meeting. Since it was first posted, there have been no changes to the agenda, so I ask that you please take a minute to review the agenda, and then we'll need a motion to adopt the agenda.
To adopt the agenda.
Okay, is there a second?
Second.
Okay, it's been moved and seconded that we adopt the agenda for today's meeting. All in favor, please indicate by saying aye.
Aye. Aye.
Any nays? Hearing none, the agenda has been adopted for today's meeting. Next is the approval of the April 2026 draft meeting minutes. We need to review those, and will a member make a motion to approve the minutes from the April meeting, please?
I'll offer the motion that we approve the minutes from the April meeting.
Is there a second?
I'll second.
It's been moved and seconded that we consider approval of the April 2026 meeting minutes. All those in favor, please indicate by saying aye.
Aye.
No opposed. Then the April 2026 meetings minutes are approved. Next, we will have a report from the Office of Open Government. Director Allen, please proceed.
Thank you and good morning, Chairperson Hutcheson and members of the board. I am Niquelle Allen, Director of Open Government, and I am pleased to present this report on the activities of the Office of Open Government, or OOG. Our mission is to ensure that all persons receive full and complete information concerning the affairs of the District of Columbia government and the actions of its officials. Since the last board meeting, OOG has continued its work to ensure that the District of Columbia government's operations are transparent, open to the public, and promote civic engagement. To that end, OOG has enforced the Open Meetings Act, advised on the Freedom of Information Act's requirements, and provided training on those transparency laws. OOG has proudly served as advocates for an open and transparent government. Open Meetings Act and Freedom of Information Act advice is first. I have issued 3 advisory opinions since the last board meeting, and they are as follows. OMA Advisory Opinion, Board of Trustees for Harmony Public Charter School, number OOG-2025-0023. On April 8th, I issued this opinion in response to a complaint which alleged that Harmony Public Charter School Board, or Harmony, had not posted meeting links or meeting locations and times on its meeting notices. The complaint also alleged that Harmony failed to publish dates for its fall 2024 meetings on the Public Charter Schools website. I dismissed the complaint pursuant to 3 DCMR section 10403.1b because I found that Harmony did not violate the Open Meetings Act based on OOG's investigation. The investigation revealed that Harmony published complete and timely upcoming meeting notices. Harmony Public Charter Schools website included the location, login information, and web link, and the time of Harmony's meetings. OOG's investigation also revealed that Harmony published an annual schedule of its 2024 and 2025 meetings. I advised Harmony to ensure that its annual schedule is updated in a timely manner if changes are made. I further advised that if a meeting notice is published and the meeting is canceled, The word canceled must be printed on all the meeting notices as soon as the board is aware of the cancellation. A copy of the complaint and advisory opinion have been added to Dropbox. The second is a dismissal of OMA complaint, also against Harmony Public Charter School Board, number OOG-2026-0009. On May 4th, I dismissed this complaint with an allegation from the same complainant, which I addressed in advisory opinion number OOG-2025-0023, issued on April 3rd. The allegation pertains to the time within which Harmony updated its annual meeting schedule. I dismissed the complaint as moot pursuant to 3 DCMR section 10403.1F because the concerns raised were the same as the complaint I dismissed, and Harmony is subject to ongoing oversight pursuant to the OMA advice issued on April 8th. Thus, no further investigation or enforcement by OOG is warranted because OOG is actively monitoring Harmony's OMA compliance. A copy of this dismissal letter and the complaint are in Dropbox. OMA Advisory Opinion, Board of Trustees for Capital City Public Charter School, number OOG-2025-0009. On April 28, 2026, I issued this advisory opinion in response to a complaint which alleged that Capital City Public Charter School Board had not published proper meeting notices. I found that the Capital City Public Charter School Board did not violate the Open Meetings Act. OOG's investigation revealed no issues with the notice of meeting requirements. As such, I dismissed the complaint. However, I recommended that if possible, that this Public Charter School Board provide access to its virtual meetings without a requirement for prior registration to access the meetings. A copy of the complaint and advisory opinion are in Dropbox. Informal FOIA, OMA advice, and technical assistance. Since the last board meeting, OOG has responded informally via email, telephone, or teleconferences to requests for assistance as follows: 19 requests for Open Meetings Act advice, 15 requests for Freedom of Information advice, and 14 requests for technical assistance with open-dc.gov. Meeting monitoring is next. OOG staff attends public bodies meetings in person and remotely to ensure compliance with the Open Meetings Act. They also inspect public bodies' websites and OOG's central meeting calendar for public meeting notices and records. OOG's attorneys provide legal advice on the Open Meetings Act compliance and take corrective action if necessary. Since the last board meeting, OOG staff have attended 19 public body meetings. As a result of the monitoring, 6 corrective measures were communicated. The public body failed to 1, publish complete meeting notice with agenda, 2, provide the statutory reason OMA citation for entering closed session on its agenda, 3, provide meeting cancellation notice, and 4, provide operable web link and login information to its virtual meeting. Also, 2 public bodies failed to provide the regulatory statement on their agendas. Next in my report is training and outreach. Open Meetings Act training for boards of trustees for DC Public Charter Schools. On April 8th, Attorney Advisor Joan Lelma facilitated an OMA training for this body. The training was second in OOG's 2026 training series for Public Charter School Board. I, along with OOG staff, attended the training. Managing the FOIA process training. On April 9th, Attorney Advisor Anthony J. Skirbo facilitated managing the FOIA process training, which was accessible in person at Bega's boardroom and virtually. The hybrid training provided a description of OOG's function and an in-depth examination of the DC Freedom of Information Act process for DC FOIA officers. I, along with OOG staff, attended the training. AI Values Alignment Public Meeting. On April 30th, I participated in the advisory group on AI Values Alignment Public Meeting at Shaw Library in Washington, D.C. The meeting included an overview of the District of Columbia government's implementation of AI tools, and the members provided updates on the areas of expertise from the perspective of AI implementation. The next meeting is scheduled for May 19th, 2026 at 6 p.m. EQS Compliance Week Dinner. On May 6th, Chief Counsel Neil joined Marco Goldberg, Managing Director of EQS Group, for EQS Compliance Week Executive Dinner. This function was part of ESQ's EQS's Compliance Week session held at the Mayflower Hotel in Washington, D.C. These sessions focus on how leading AI models perform across real-world ethics and compliance tasks and how senior ethics and compliance leaders rethink the ways in which they are activating their data in today's ever-changing world. Litigation and legislation update. Litigation, Council of the District of Columbia versus Muriel Bowser, case number 2026-CAB-001463 in D.C. Superior Court. This is an update on a lawsuit filed by the Council of the District of Columbia against Mayor Muriel Bowser in her official capacity. The complainant alleges that the mayor unlawfully refused to provide the council with certain agency budget enhancement requests for FY25 and FY26 requested by council committees as part of the council's ongoing performance oversight process. The complaint further alleges that the council anticipates the mayor's refusal to provide any agency budget enhancement requests for FY27. The mayor filed a motion for an extension of the briefing schedule on April 11th. The council filed an opposition to this motion on April 13th. The mayor filed a reply brief in response in support of her opposed motion for an extension of the briefing schedule that same day. On April 14th, the court issued an order granting in part the mayor's motion for extension of the briefing schedule. On April 23rd, the mayor filed a combined motion for summary judgment in opposition to the plaintiff's motion for summary judgment and declaratory and permanent injunctive relief. On April 30th, the council filed this combined reply in support of its motion for summary judgment and cross opposition to the defendant's cross motion for summary judgment. A status hearing has been set for May 15th. Copies of the documents have been added to Dropbox, and OOG staff will continue to monitor this important case. Legislation and rulemaking. Legislative action regarding the Open Meetings Act, Bill 26-0632, the Open Meetings Clarification Emergency Amendment Act of 2026, and Bill 26-0633, the Open Meetings Clarification Temporary Amendment Act of 2026. As reported last month, on March 31st, the council passed this emergency bill. The bill was transmitted to the mayor on April 2nd and returned from the mayor on April 17th. It was enacted on April 18th without the mayor's signature as Act 26-0297 and will expire on July 17th. Bill 26-0633, the temporary bill, passed on May 5th and will become effective retroactively as of March 29th and will be effective for no more than 225 days. Legislative action regarding body-worn camera regulation and reporting requirements of 2015, FOIA-related legislation. I reported on these council members at the last two board meetings. The bills temporarily require the Metropolitan Police Department, or MPD, to release body-worn camera footage whenever an MPD officer is present during a serious use of force incident, even if the force was used by a federal officer. They also require the release of all names of law enforcement officers involved. The first one is Bill 26-0614, the Full Accountability in Arrest Recording Emergency Amendment Act of 2026. As previously reported, the mayor vetoed this bill on March 23rd, and the council voted unanimously on March 31st to override her veto, and then voted unanimously to approve the measure. It was enacted without the mayor's signature on March 31st as Act 26-0290 and was published in the D.C. Register on April 10th. The act will expire on June 29th. The next one is Bill 26-0615, the Full Accountability and Arrest Reporting Temporary Amendment Act of 2026. On March 31st, the bill passed unanimously after its second reading. It was transmitted to the mayor on April 13th and returned unsigned on April 23rd. The measure was enacted without the mayor's signature as Act 26-0304 on April 29th. The next is Bill 26-0617, the Body Worn Camera Transparency for Use of Force Temporary Amendment Act of 2026. I also reported on this measure at the last board meeting. The legislation requires MPD to release body-worn camera recordings in the event of an officer-involved death or serious use of force by a law enforcement officer other than an MPD officer. On March 31st, Bill 26-0617 passed unanimously, and the measure was transmitted to the mayor on April 13th. The legislation was signed by the mayor on April 22nd and was enacted with Act number 26-035. The mayor returned the measure the next day, and it was transmitted to Congress on April 29th and published in the D.C. Register on May 1st. Legislative action regarding the D.C. Freedom of Information Act. On April 6, Chairman Mendelson introduced Bill 26-0655, the Protecting Judicial Privacy Act of 2026. This measure would, quote, prohibit government agencies, individuals, businesses, private associations, and organizations from, upon receipt of a written request, publicly displaying available content that includes a judicial officer's personal information, end quote. This bill has been referred to the Committee on Judiciary and Public Safety with comments from the Committee of the Whole. Legislative action regarding new district data privacy law. On April 27th, Councilmember Brianne Nadeau introduced Bill 26-0670, the District of Columbia Data Privacy and Protection Act of 2026. The measure establishes comprehensive privacy protections governing the collection, use, sale, and disclosure of individuals' personal data by the district government agencies and third parties. It also confers specific right upon individuals regarding their personal information. The measure provides for the creation of a Chief Privacy Officer position within the Office of the Chief Technology Officer to ensure agency-wide compliance and implementation. Last is the Director of Open Government's notice of proposed rulemaking regarding the Open Meetings Act closed meeting requirements. On January 6th, I issued a notice of proposed rulemaking pursuant to DC Official Code Section 1-1162.05CA3, creating a new section governing procedures public bodies must follow to enter closed meetings. After reviewing public comments, the Office of Open Government narrowed the circumstances under which a public body may vote in advance to close a future meeting. I issued the revised notice of proposed rulemaking on May 6th. Commenters expressed concerns that allowing a public body to pre-authorize a closed session on a different day than the meeting itself is inconsistent with the Open Meetings Act and could diminish the public's ability to challenge improper closures. Under the earlier draft, public bodies with adjudicatory functions could vote to close a session prior to a public meeting, potentially limiting real-time objections. The revised amendment to Title III of the DCMR established new Section 10411, which sets forth clear procedural requirements for entering closed meetings. This section now clarifies that closed sessions must occur immediately after the public body votes to close the meeting, except when an adjudicatory body meets with counsel to obtain legal advice under DC Official Code Section 2-575B4. In that limited circumstances, the body may vote no earlier than the public meeting immediately preceding the planned closed session to receive legal advice prior to opening a meeting to conduct an adjudication or hear contested cases. The amendments also clarify the meaning of, quote, subjects to be discussed in Section 2-575C2. The revised notice will be published in the DC Register in the May 15th edition for a 30-day comment period. Copies of the legislation, rulemaking, and supporting documents are in Dropbox. Last are administrative matters, FY 2027 budget oversight. The Committee on the Judiciary and Public Safety Committee provided correspondence to Chairperson Hutcheson on April 29, 2026 that included questions regarding Bega's FY 2027 budget proposal. The committee did not have any questions regarding OOG's budget. Bega's Chief of Staff, Christina Mitchell, provided responses to questions on behalf of the agency on May 4th. The committee has not scheduled a budget hearing for Bega. Last is OOG's attorney advisor, Angie J. Skirbo, Capital Pro Bono Honor Roll recognition. On April 21st, Chief Judge Anna Blackburn Rigsby of the D.C. Court of Appeals and Chief Judge Milton C. Lee of the D.C. Superior Court released the 15th Annual Capital Pro Bono Honor Roll, recognizing D.C. Bar members and others authorized to perform pro bono legal work in the district who completed 50 or more hours of pro bono service last year. OOD Attorney Skirbo was recognized on the High Honor Roll, having performed over 100 pro bono hours in 2025. Congratulations, Anthony. We are very proud of you. This concludes the Office of Open Government's May 7th, 2026 report. I'm happy to answer any questions the board may have.
Thank you. We also congratulate Attorney Skirbo. Any questions for?
Quick one.
Yeah.
Again, great job, Anthony. Really, really nice job. Maybe next year we'll see if you get the Pro Bono Attorney of the Year award at the DC Bar. Keep up the good work. Yeah, just on the rulemaking, the criticism was that by pre-authorizing the closure of a future meeting, that it would not give folks enough time to object to it. It seems to be the opposite. By doing that, it would be. I'm just trying to figure out what the commenters were so upset about.
So I guess the framework is more so for in-person meetings where people are in the room and they're able to object to a closed session, that there would be no opportunity to do that in this circumstance. Before we had made it more broad, so we could see that there might be an opportunity for abuse. And this was really just an administrative matter for when boards such as our board needs to meet with their attorneys prior to hearing a case, just to get a confidential legal briefing from counsel. So instead of having people wait online for an hour or however long that takes, it was more expeditious for the bodies to be able to vote prior to that contested hearing or adjudicatory hearing, to meet with their attorneys before the meeting.
Right, and because it would seem to me that you guys are, you're statutorily authorized to march into court and open a closed meeting that should not have been closed. And wouldn't you want that extra time to know that one was going to be improperly closed?
Yes, I would think so. So hopefully they'll be more satisfied with this version, but we await their comments and any of their comments.
All right, good luck.
Thank you.
Any other questions for Director Allen? Thank you, Director Allen.
Yeah.
Next, we'll go to the report from the Office of Ethics, Government Ethics, and a report from Director Hooks. I'm sorry.
Good morning, Chairperson Hutcheson and members of the board. I'm Ashley Cooks, Director of the Office of Government Ethics. I'm pleased to present this report on the activities of the Office of Government Ethics, OGE. First is an update on the status of OGE investigations. The information reported today regarding OGE's cases will not reflect any status changes that may occur because of actions taken by the board during today's meeting. For open investigations by status, we have a grand total of 76. Open undocketed matters, we have a grand total of 7. Pending state investigations by status, we have 33 matters that are closed pending collection, 3 matters stayed pending DC Superior Court case, 3 matters stayed for OIG investigation, 2 matters stayed for U.S. District Court case, for a grand total of 41. For regulatory matters by status, we have 67 matters that are closed pending collection, 637 matters that are open, for a grand total of 704. Again, we currently have 76 matters that are open and 8 matters that are stayed. The number of open preliminary and formal investigations includes 18 new matters. The investigative team resolved 6 investigations since the board last met. This total does not reflect the number of complaints that were dismissed for a lack of jurisdiction. Next is an update on training and outreach. First, professional development trainings attended by staff. Since the last board meeting, almost all OGE employees completed OCTO's mandatory artificial intelligence training entitled Responsible AI for Public Professionals, using generative AI in government. For trainings conducted by staff, Since the last board meeting, OGE conducted 8 training sessions, the March Brown Bag session, a hashtag training for the Criminal Justice Coordinating Council, the quarterly outside employment training, the April monthly ethics training, and April monthly hashtag training, the quarterly boards and commissions training, and Office of Administrative Hearings ethics training, and a new employee orientation. In April, 182 learners completed 228 courses on the LMS. 1,948 district employees completed ethics training using PeopleSoft, and 45 new employees attended new employee orientation and received information on the district's ethics rules in April. For advisory opinions and advice, first, informal advice. OGE's legal staff provided advice for approximately 42 ethics inquiries, which is 8 more than the 34 reported at the April board meeting. This number does not include responses we have provided to questions regarding the lobbyists and FDSE filing systems. For an update on formal advisory opinions, on April 30th, 2026, OGE issued formal advisory opinion, representation through testimony, which clarifies that the Code of Conduct does not prohibit board or commission members from testifying before or providing information in their official capacity to the DC Council regarding the board or agency's budget. The opinion responds to a question of whether board members for the Food Policy Council may testify or provide information regarding the mayor's proposed FY27 budget for the Office of Planning, which would defund the Food Policy Council. The opinion has been posted to the Bega website and was sent to the DC Register for a 30-day comment period. Next is an update on legislation and rulemaking. The financial disclosure rulemaking, B26-0325, Board of Ethics and Government Accountability Authority Clarification Amendment Act of 2025 is still pending. This legislation is in response to Bega's rulemaking, which designated 43 board and commission members as public financial disclosure statement filers and will repeal Bega's authority to make such designations in the future. Chairperson Hutcheson and I testified at the public hearing regarding the legislation in January 2020, on January 13, 2026. Council Chairman Mendelson has indicated that he will amend the legislation with the intent that it passes before the council's recess. On April 18th, the council passed B26-062632, Open Meetings Clarification Emergency Amendment Act of 2026, which halts the applicability of Bega's rulemaking until October 17, 2026. And this Tuesday, the council passed B26-0633, the temporary legislation, which does the same as the emergency. As a result, none of the designated board or commission members have filed a statement with Bega. Given that financial disclosure is a key to promoting public trust and transparency within the district government, any legislation that hinders that process does not serve the interests of the government and the residents of this city. Nonetheless, Bega will continue its efforts to promote an ethical and transparent government by educating and advising employees on the ethics rules and holding accountable those public officials who violate the ethics rules. Next is an update on OGE administrative matters. First is OGE staffing. OGE has one attorney advisor vacancy pending, which we plan to fill within the next month or two. For budget, on April 10th, the mayor submitted her FY27 budget and budget support act to the council. Bega's proposed budget is $4 million, which includes $3.9 million in local funds and $158,000 from special purpose revenue. The Budget Support Act proposes a transfer of $28,000 from Bega's lobbyist fund for fiscal years 2027 through 2030, and a transfer of $19,000 from the Accountability Fund in fiscal year 2030. These transfers are in addition to the already existing sweeps that were passed in the FY26 Budget Support Act. This past Monday, OGE and OOG submitted answers to the budget oversight questions that were sent to us by Councilmember Pentel's office. Bega has not been given a hearing date for a budget oversight hearing. Next is an update on financial disclosure statement, FDS. Pursuant to DC Official Code Sections 1-1162.24 and 1-1162.25, public officials and certain government employees who must file a financial disclosure statement as a means of transparency to prevent engaging in conduct that violates the financial conflict of interest statute. Bega is responsible for ensuring that employees and public officials who meet the statutory requirement file their annual financial disclosure statements. The 2026 FDS season is underway. The deadline to file financial disclosure statements is May 15th, 2026. The FDS team sent out initial mailer notices and email notices on April 15th. The team sent hard copies to all public filers and continues to send weekly reminders to those filers who have not yet filed. 4,765 out of 9,569 filers have filed their statements thus far. Last is an update on lobbying registration and reporting, LRR. Pursuant to DC Official Code Section 1-1162.27A, a person who receives compensation or expends funds in an amount of $250 or more in any 3 consecutive calendar month period for lobbying shall register with the Director of Government Ethics and pay the required registration fee. According to DC Official Code Section 1-1162.30, each registrant shall file a quarterly report concerning the registrant's lobbying activity during the previous quarter. A notice regarding quarter 1, April 15th filing deadline was sent to all registered lobbyists on March 24th, 2026. 452 activity reports were timely filed as a result. Thank you. This concludes my report for the May 7th board meeting.
Thank you, Director Cooks. Are there any questions for Director Cooks?
Director, I was just going to ask about the ongoing dispute with the council with respect to the financial disclosure issue. Is there any middle ground here that they are either proposing or that we should consider? Because it seems like they're digging in their heels. And unless I'm wrong, it's because they worry that they can't get enough board and commission members to serve on these important positions if they have to share so much of their financial life with the public.
So when we met with several council members, one suggestion was to have the public officials, those who were designated to file confidential statements, as a middle ground. That was, what else? I think that was the only offer of a middle ground that we've heard from the council. The majority of surprisingly, adverse to the vote that took place on Tuesday, the majority of the council members who we've met with have agreed that those boards that we designated should be filers, except for Chairman Mendelson, especially Councilmember Henderson, who has jurisdiction over many of the medical boards that we designated. Those boards are licensing boards. She especially thought that the rulemaking should take place. We haven't received much in those meetings, information on middle grounds or any opposition to that fact about the FDS rulemaking, again, except for one council member in particular. And his view was that the boards, the Construction Coordinating Council and the DC Retirement Board should not be filers. DC Retirement Board are already filers. They just don't file with us.
Do they file publicly?
They file publicly, but it's posted on LIMS. It's not anywhere that's readily available to the public. You have to do some searching on LIMS to find their financial disclosure statement.
Yeah, and especially, the retirement board, which is in charge of so much money and so many decisions when it comes to fiduciary accountability. They should definitely be, well, they're public filers. It's disappointing that they're digging their heels in so much. We'll see where it comes out.
I wonder if the I will say that the permanent legislation that's pending that would strip our authority, did not get much support. I would say that because the FDS legislation has been, the temporary and emergency ones that have been passed have been placed inside of other types of legislation, which is the reason I believe that it continues to pass on a temporary and emergency basis. So
Sort of a congressional tactic there when it comes to the district's budget.
Exactly.
Put a rider somewhere in another piece of legislation. Oh, well, that's politics.
Any other questions? Okay. Then the next item on our agenda are public comments. Members of the public who are in attendance at this meeting have an opportunity to make a comment at this time. Okay. If there are no comments from the public, we'll proceed to the next item on the agenda, and that's our executive/closed session. This is a closed session to discuss ongoing confidential investigations pursuant to DC Official Code Section 2-575B14, to consult with an attorney to obtain legal advice and to preserve the attorney-client privilege between an attorney and a public body pursuant to DC Official Code Section 2-575B4A, to discuss personnel matters including the appointment, employment, assignment, promotion, performance evaluation, compensation, discipline, demotion, removal, or resignation of government appointees, employees, or officials pursuant to DC Official Code Section 2-575B10, to deliberate on a decision in which the Ethics Board will exercise quasi-judicial functions pursuant to DC Official Code Section 2-575B13, and to discuss contract negotiation strategies pursuant to DC Official Code Section 2-575B2. May I have a motion to enter into executive session?
So moved. Second.
Ooh.
Thanks.
Okay, it's been moved and seconded at least twice that the board enter into executive session. All those in favor, please signify by saying aye.
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 Okay, the motion passes unanimously. So board members, please move over to the boardroom for the executive session. We will return to this meeting after the conclusion of the executive session to report on any matters decided, finish any other business, and adjourn the meeting. Thank you. Okay, the time is now 11:45 and we are back on the record. The board approved the following formal investigations: 26-0003-F in Ray Matthew Mall and 26-0097-P in Ray Phil Mendelson. The board dismissed 24-0011-P in Ray Dana Garnett, and the board approved a notice of hearing and scheduling order in 26-0004-F in Ray Cleo Sabito. The next board meeting will be held here at the Board of Ethics and Government Accountability, 1030 15th Street Northwest, Suite 700 West, and virtually on June 4th, 2026 at 10 a.m. With that, we are adjourned to tell everyone to have a great holiday. I think we have two holidays, Mother's Day and then Memorial Day before we'll meet again. Thank you.
Thank you.